The Texas justice system is messy, so let's break it down. You're listening to So You Got Arrested, the podcast that tells you what really happens after an arrest. Hosted by BRCK Criminal Defense attorneys, we talk to the people who've lived it, worked in it, and been shaped by it. Whether you're facing charges or just want to understand your rights, your options, and the smart moves that could change everything, we've got your back.
So we hear these phrases and terms that get thrown around a lot in movies and TVs. And so today, I wanted our colleague, James Heath, to kind of address some of these things that we hear. A big one that I hear a lot in movies that a lot of people don't understand is when somebody says, I plead the fifth, I plead the fifth. What does that mean to plead the fifth? And does that mean, you don't have to talk to anyone? Does that mean after that, anything you say, you're not in trouble anymore? You kind of explain that to us. Right.
So pleading the fifth comes from the Fifth Amendment of the Constitution of the United States of America, contrary to popular belief, which would be the Chappelle Show, I believe. But in the Fifth Amendment, it says you have the right not to incriminate yourself in a criminal matter. Mm-hmm. So when you plead the fifth, you would be stating, right, that you're asserting your right to not answer a question that could incriminate you.
And so I've had cases where, it's not the defendant who's trying to plead the fifth. And I don't know if you've ever had this, Scott, but it's just a witness.
Right. We've had witnesses who we've pulled in front of the grand jury before as a prosecutor who say that they want to plead the fifth. I'm like, you don't have a Fifth Amendment right. If you're not a suspect, you don't have a Fifth Amendment right. So witnesses do not have Fifth Amendment rights.
Right. And that comes up from time to time. I'm interviewing a witness and I'm saying, well, look, the state may subpoena you. They're going to put you on the stand to testify. And they say, well, I'm just going to plead the fifth. And it's like, well, you can't do that.
You don't have a Fifth Amendment right unless you're accused or suspect in a crime.
Yeah. And so a lot of these things that we see and that we hear about in these movies and these TV procedural dramas stem from these amendments to the Constitution. And it's primarily the Fourth Amendment, which prevents unlawful search and seizure, and then the Fifth Amendment, which has the right against self-incrimination and a whole host of other rights. So, James, I know there were some of these rights that you wanted to discuss. What do you want to talk about?
Well, I think first and foremost, it's important to put it out there that there's different sovereigns. So I think the federal Constitution really covers the baseline minimum rights that you can't. No state can fall below what's in the Bill of Rights right there. However, states can write their own constitutions that give greater rights. Mm-hmm. So most people are going to be able to point to not only a federal right but a state constitutional right as well. Mm-hmm. And in Texas, I do believe that there are many circumstances in which the Texas Constitution provides for more rights than the federal.
Provides for greater rights than what's afforded to us under federal law.
Absolutely.
Yeah. So let's talk a little bit about, I always have, this discussion with clients that they say, well, they arrested my son and my son just called me from the jail and said that when he got arrested, they didn't read him his rights. So can we get the case thrown out? Right.
So that would be a Miranda issue, right? So it's falling under the Fifth Amendment, United States versus Miranda. And Miranda is a tricky thing, right? So Miranda is going to apply, to statements, but there has to be two prerequisites that are triggered for Miranda to apply. Those are, custody and interrogation. Mm-hmm. So custody is essentially, a reasonable person, the hypothetical reasonable person would not feel free to walk away.
Mm-hmm. So you have to be in law enforcement custody.
Right, absolutely. From some state actor, some state employee, state authoritarian.
Mm-hmm. And so the guy running out of his apartment covered in blood saying, hey, I just stabbed her as the cops pulling up would probably not be in custody for that right to apply.
Absolutely not.
Okay. And then you said there was a second.
Right. So that's interrogation. So the question phrased to you, right? So you're in custody, you can't leave. If they're asking you incriminating statements, right, then there's a chance that later on those statements can be ruled inadmissible. But I think the textbook example is the DWI. You get, handcuffed, you get put in the back of the car. You're unaware that you're being recorded in the back of the police car, and they're rummaging through your car looking for what they can find. And you say, God, I can't believe I drank that much. Well, no one asked you a question. You just volunteered that information, and it can absolutely be used against you.
So in that circumstance, Miranda would not apply.
Absolutely.
I've had it happen. I was a special prosecutor on a murder case up in Hayes County, and he took them to show the SAPD where the body was, his girlfriend's body. And on the way back, not in response to questioning, so that's the prerequisite. He asked the officer, "How much do you think I would get for a murder?" Okay, but it wasn't in response to a question, so that stuff was admissible, even though he was in custody.
Well, there's this fantastic documentary on HBO called The Jinx, and it's about Robert Durst. And I don't know if you guys have seen it, but it's famous for this reason that after they're interviewing him, and he almost has this moment like from The Naked Gun where he goes into the bathroom with his mic still on, and in The Naked Gun, Frank Drebin does it, and you can hear him urinating. But Robert Durst is in the bathroom, and they've asked him all of these questions about this murder. And he says, well, that's it. They've got you, and basically confesses to a crime on this recording. And on that recording, obviously, he's not in state custody. He's sitting down for this voluntary interview with, these documentarians. And it's not the product of interrogation because he's by himself and he's just kind of talking out loud. And, that was just I remember watching that documentary for the first time, and it was such a jaw-dropping moment, just realizing what's happening. And he ended up being convicted.
Right. Absolutely.
And so legally, we call those res gestae statements. Just for you people at home, when you hear attorneys talk about res gestae, that means statements not in response to questioning.
Mm-hmm. Yeah. And so with regard to these rights, in my experience, a lot of the interaction that people have with law enforcement seems to revolve around a vehicle, right? It's you're getting pulled over for some kind of traffic infraction, and that starts the encounter with police. Now, there are certain rights that are attached to those encounters, right?
Absolutely.
Okay. So what are those rights? Kind of walk us through them.
Right. So there's levels of approved interest, right? So the house is number one. Your house is something where 9 times out of 10, law enforcement is going to need a warrant, right, to do some sort of search. But a vehicle is deemed much less private, right? You're on the highway, you're on the road, everyone can see you.
And this has to go to your expectation of privacy, which is a big thing in constitutional law. In your home, you have a much higher expectation of privacy than you do, say, in your automobile. Absolutely, right? And so, to the Fourth Amendment is what we're talking about, searches and seizures, right? There's exceptions, and there's several that cover the automobile. One appropriately named the automobile exception. And the basis of that exception is that we're not very creative in the law.
Right. Vehicles are mobile. Right. So if there's not time to get a warrant, evidence can be destroyed, people can get away. So they've created this exception that trumps the warrant requirement of the Fourth Amendment. Right.
And so like one of the exceptions I know is if the officer has probable cause to believe that an offense is being committed. Right.
Absolutely.
And so I was watching a video sometimes in my off time, as crazy as it sounds. I watch these videos on YouTube of people being arrested in other states. I don't know why I do that because that's all I do at work. So, but I was watching this video and there were these people who were pulled over and they're being asked these questions about where you headed and they've separated out the driver and the passengers and they're asking them questions. Where are you going? How do you know him? How do you know him? And it's clear that they're lying. I mean, they're just not, the answers are completely inconsistent. And so the officer at the scene, you can tell she kind of wants to search that car at that point, but she really has no reason to. So she's talking to her supervising officer saying, well, these answers are inconsistent and I think they may have something. And the first thing that the supervisor says is, well, do you smell any marijuana? And she says no, which I was impressed with because a lot of times she would just say,
right.
Yeah, I do. But kind of talk to us about that.
Right. So the smell of marijuana is going to give probable cause for a search, especially, in a vehicle context. Again, the basis for that is that at the time of the exception, there's really no other smell that's recognized as smelling like marijuana.
Mm-hmm.
So you can rule out pretty much everything else, right? Mm-hmm. So there's some argument about now with hemp being, legal, but
not much longer because
right.
Congress just approved the ban on hemp products late last night. But
so the exception will live on forever, I'm sure. But so probable cause is, facts or circumstances that would lead a reasonable person to believe that a crime has been committed or is being committed, and possession of marijuana is a crime. The smell of it is linked to only marijuana, and therefore probable cause exists to go and try to retrieve it.
Yeah. And we've kind of talked about that before, Scott, where we have clients who, so in this case, this video that I was watching on YouTube, they had 25 pounds of methamphetamine. Okay. Now, to their credit, they weren't smoking marijuana. It didn't smell like marijuana. But it's not uncommon where we see cases where somebody has a large amount of contraband and then they've just smoked a joint right before they hit the highway. And it's like, what were you thinking? Yeah. I mean, you've given them a reason to search that vehicle.
Right.
Absolutely. And a lot of times they'll say, well, I smoked 3 days ago. And that's going to do it every time as well.
Mm-hmm. Yeah. It's still on their clothes. It's still in the, in the upholstery of the car, or they still have the roach in the ashtray, whatever the case may be. So let's say that the officer does not have probable cause to believe that an offense is being committed. Is there any other way in which they get to search that vehicle? Let's say you say, no, you don't have permission to search my vehicle. What happens?
Right. So there's a lot of things that can happen. I think here, the prominent two avenues would be, right, they would request for some sort of dog to come out.
A canine unit.
Right. A drug sniffing dog. Right. And it has to, the touchstone, the benchmark of the Fourth Amendment is reasonableness. So there is kind of a clock that works against them. Right. They can't keep you out there for 2 hours waiting for a dog to show up. Again, in Texas, most any offense is an arrestable offense. So a ticket, a Class C misdemeanor is an arrestable offense. If they arrest you and there's no one to take your car, depending on...
You know what the two exceptions are on the ticket? The two Class C misdemeanors you can't be arrested for? Do you know this?
Minor possession?
Speeding and open container.
Okay.
Which is crazy.
Yeah.
You can't be arrested for those two things. You can be arrested for anything else. For running a stop sign, whatever the case may be. Technically, you could be arrested.
Right. Absolutely. And there's other ways, there's other exceptions for them to get into the car. If you're under arrest and your car's on the side of the road, they're under no obligation to leave it there. Right. So they
don't even have to let you have a friend come and get it.
Correct.
I've had cases where the passenger is there and they don't allow the passenger to take the vehicle. They just tow it.
So tell us about, so when they tow it, what are they going to do to the car?
So when they tow it, they're going to inventory the car. The inventory search exception. The basis of this is that there's liability when someone else comes and takes your stuff and they don't want to get sued. So what they're going to do, it's not supposed to be for investigation purposes, but realistically, a lot of times it is.
It is.
So they're going to go through your car and they're going to inventory the contents of it. And in that process, they're going to open up your glove compartment. They're going to open up your center console and they're going to look in every nook and cranny.
Your
everything
that you have. Earlier, you had talked about the canine unit. If they're walking that dog around the vehicle and the dog signals, what happens?
So that's going to give probable cause for a search.
Mm-hmm. And Scott, I know you've worked in a rural jurisdiction. I would imagine most jurisdictions, including rural jurisdictions, have canine units available.
Oh yeah. Now, depending on so in Medina County, there's only one canine unit, so you may not be able to get them. And of course, what James says is accurate. They can't keep you on the side of the road for an hour and a half waiting for a drug dog.
Mm-hmm.
So if they're not going to come in a reasonable amount of time, which reasonable hasn't been clearly defined by the courts, but we know 2 hours is too much, then you're going to be okay. They're not going to be able to do it. So, but a lot of what they're hoping, they may know that their drug dog's not available.
You're going to freak out.
You're going to say, well, we're just going to get the drug dog. Okay, you can go ahead and search it. And what they tell you is it'll take the drug dog a couple hours to get here. Now, so they're not allowed to make you wait a couple hours, but you don't know that. So you say, well, if it's going to take a couple hours, go ahead and search.
Go ahead and search. So that takes us to our break. We'll be back. This is So You Got Arrested with BRCK Criminal Defense.
The attorneys at BRCK Criminal Defense have helped over 5,000 clients move on with their lives. When an arrest or accusation turns your life upside down, we have the knowledge, experience, and integrity to get your life back on track. Traditional legal ethics, modern legal tactics, the best defense possible to get you through the criminal justice system. Search BRCK Criminal Defense to see our reviews and find out why so many of our clients have trusted us to fight for them. BRCK Criminal Defense, helping our clients move on with their lives.
So we were talking about this inventory search, and for this inventory search to apply, it seems like a lot of jurisdictions are using this, which may explain why they're towing these vehicles instead of letting the passenger drive them. That way they can conduct one of these inventory searches. But they don't just get to do the inventory search just whenever they want. There has to be, I think, a specific policy in place.
So each law enforcement agency has to have an inventory search policy. It doesn't have to be in writing, but they have to be able to talk about it. So you can't sit there and say, well, we don't have a policy about inventory searches, but we're going to search this guy's car because we're going to win on the motion to suppress on that.
Mm-hmm.
Okay. So there has to be a standard of what their procedures are for when they do not do an inventory search. For instance, some jurisdictions say, well, if the car is parked safely in a non-public, not on the roadway, we won't tow it. So therefore you don't do an inventory search. Mm-hmm. So once they've established the policy, they have to follow the policy. And it's not statewide policy or federal policy.
It's local.
It's local police jurisdiction.
That department.
Exactly
so the sheriff's department policy may be different from the local police department policy.
It generally is.
Right.
Depending on their ability, where their impounds are and stuff like that.
Yeah. And the interesting thing is, these inventory searches became much more common and prominent after the Supreme Court kind of really cut the legs out from under what we used to call search incident to arrest. You may not remember that because that was a while back, but kind of go through that.
I was in the middle of all that when the Supreme Court took up.
It was Scott violating people's constitutional rights.
Well, it was Arizona. The case was Arizona v. Gant. And what happened is, and it's interesting because a lot of times as a prosecutor, defense attorneys would say to me, well, why would my guy agree to a search if he knew he had cocaine in the car? But people are stupid, and Arizona v. Gant illustrates it. Mm-hmm. So the case in Arizona v. Gant is the police they knew this house they were dealing drugs out of the house. They had knocked on the door looking for a guy that had a warrant for this guy, but it was a misdemeanor warrant, but wasn't Gant. But Gant answers the door, and they say, is so-and-so here? And he's not here. But they ID him, and they go back and they realize Gant had a misdemeanor warrant. Well, you can't go into the house on a misdemeanor warrant, but they kept it in their head, right? They realize next time I see Gant, he's got a warrant for his arrest. Mm-hmm. Eventually, they get a search warrant for this house, and they got everybody outside. They got all kinds of drugs in the house. They got everybody outside laying on the ground, arresting them. And here comes Gant driving back up. Wouldn't you think that, and he had drugs in the car, you'd think if you're driving up and you see all your buddies on the front, you'd keep driving. No, Gant pulls into the driveway and says, what's going on here? They immediately arrest him.
Why are all my drugs on the lawn?
But they arrest him, and then they search his car incident to arrest. And there's a bunch of drugs in his car too. Mm-hmm. Okay.
And because it used to be the policy that when you arrested somebody,
you could search his whole vehicle.
So the crazy thing was that the logic was, well, we're taking them into custody. They may have something dangerous in the vehicle.
Right.
But you would have these guys that were in custody. Right. They were 20 yards away from their vehicle. They're not able to get back to the vehicle to grab a gun or anything like that.
Which is what Scalia said in his opinion. So it's a Scalia opinion. And basically he said, there's never been a documented instance once somebody got arrested that they were able to get back into their vehicle. So we're no longer going to allow them to do a search of the vehicle, search incident to arrest. That night so I had told all the detectives at SAPD, the Supreme Court took that Arizona case because we're going to reverse it. We have years and years of case law saying police are allowed to search a vehicle, search incident to arrest. And I'm like, so clearly they're going to reverse the Arizona courts. But that's not what they did. Scalia wrote this opinion saying there's no reason to search a vehicle once you've got a guy arrested in the back of your car. And so that night I was down talking to Rope to detectives about, what are we going to do now? And I said, well, maybe you can leave him in the car and then you can still search. And the detective's like, we're not going to risk the officer just so we can get a search of the vehicle.
Right.
And so what ended up happening.
So this is how the sausage is made.
Yeah, this is how the sausage is made. I've been told nobody's interested in how the sausage is made. But anyway, so what the agency said, well, we're just going to do inventory searches now. Now they wouldn't have been able to do it on Gant though, because he was in his driveway.
Right.
But that's not how.
That's one of the opinions where the Supreme Court actually, extended our rights and gave us additional protections, which, in the realm of criminal law, usually the defense doesn't always get the outcome that we want from the U.S. Supreme Court.
And it was a common sense opinion, but we had been so ingrained that you can search a car, search incident to arrest, that it just never occurred to us that this would change. But that's the interesting thing about how sometimes laws change.
And now as a consequence, we have more of these inventory searches where vehicles are getting towed just so they can conduct that inventory search.
Right. And so remember, whenever you're talking about search and seizure, a lot of our clients say, well, I had an expired registration, but they pulled me over because they saw me coming from a place that's selling drugs. Pretext doesn't matter. It doesn't matter that the officer had another reason why they did it, as long as there's a legit reason to do it. Mm-hmm. So if you have an expired registration and you know damn well they're pulling you over because you're coming from a drug house, we don't win because we say they didn't really pull me over for the expired registration. It doesn't matter. As long as they had the reason to, they win.
Mm-hmm. Absolutely. Mm-hmm. And I think it brings up a good point with the Gant conversation that, they can claim one exception and it not apply, but as long as some exception applies, it's likely that the search will be saved.
Well, and now they have like a good faith, exception to where, the officer. So what's been happening lately is there was this decision, I believe it was out of North Carolina, where the officer said he observed a traffic violation, and that gave him reasonable suspicion to stop. It turned out there was no traffic violation. And the courts have said, well, but in his head at that moment, he genuinely felt there was a traffic violation. That's good enough for us. I actually had that case cited against me recently where I had a video that showed my client did not commit a traffic violation. And the officer had this traffic violation listed in the report, and the video showed he didn't commit that. And the prosecutor says, well, here's this case out of the Supreme Court. It's still something to be argued, but
right, because they still can't lie about it. It still has to be truthful. I mean, if they're lying about it, if they say you had a broken taillight and there's not a broken taillight, then we still may win that argument. Right. I understand what you're saying about that case, but I think we could still win that argument. You may feel differently.
No, I agree. I think the touchstone of the Fourth Amendment is reasonableness. It's unreasonable to say that a headlight or a taillight is busted when it is in fact not.
Yeah.
So, we're coming up on the holiday season. So next week is going to be Thanksgiving, and families are going to get together. They're going to watch that Dallas Cowboys game. People are going to probably have a few drinks. Shortly thereafter, the Texas Longhorns are going to beat the Aggies. Everybody's going to go crazy and celebrate, and maybe have a few too many drinks. And some people, even though they shouldn't be doing this, our advice is always you need to call an Uber. Some people are going to drive home. Okay. So they're going to get pulled over. What's your advice? Kind of walk somebody through a stop from beginning to end. What should they be doing?
Right. So what I would say is you're going to be pulled over for hopefully some sort of traffic violation. And the cop is going to approach either the driver's side window or the passenger window. Right. They're going to ask you basic questions: where you're coming from, where you're going to.
Should you say, "Oh, I'm coming from a bar. I just had 5 drinks"?
I would advise against that. You really don't need to tell them where you're coming from and where you're going to, although obviously it's going to raise suspicion. It's good to cooperate, but it's also better to protect yourself. If you know that you're inebriated, the best thing to do would be to play it smart, in my opinion.
And play it smart means
don't incriminate yourself.
What about when they ask you, well, I just want you to perform these tests out on the side of the road. They're simple tests. How should you handle that?
Well, the tests, in my opinion, are not simple at all. I think they're designed to make you fail. I don't think that many sober people could successfully do them. And it's going to be used as evidence against you should charges be brought. If you don't do the tests, again, they're going to use it against you as some sort of refusal evidence that you're intoxicated.
And you're going to be arrested.
But
if you do the tests and you fail the test, you're going to be arrested. And now you've given evidence. Absolutely.
Catch-22. And some of those tests, some of those videos can be really, really harmful for a case.
And when it comes to, hey, I want you to blow in this machine, or I want you to give blood, kind of what's the advice on that?
Well, there's kind of different schools of thought. I know I've talked with Scott about this before.
It's a controversial issue.
Right. Some of these Intoxilyzers, depending on where you are, like any machine, they have to be...
And this is the breath test, the Intoxilyzer.
Correct. They have to be calibrated. They have to, like an engine. You need to get your oil changed. And sometimes they're not. In a case where the Intoxilyzer isn't properly calibrated or properly maintained, right, the breath can be suppressed. Also, in circumstances where the operator of the machine isn't qualified to do it, it can be suppressed. But you have no way of knowing that going into it.
You can't ask the officer, when's the last time this was calibrated.
Plus, the other thing you got to know that so in Bexar County, if you refuse to blow, they're going to take your blood. Right. And we have an easier time because not only about the Intoxilyzer being calibrated, but jurors don't trust the machine like they do a blood test. Mm-hmm. So we struggle to win on blood test cases. Actually, it's a very hard shot when they took your, because people trust blood. Mm-hmm. People don't really trust the Intoxilyzer. Mm-hmm. So the question is, well, if you refuse to blow and they're going to draw your blood, should you just blow because we have a better chance at fighting? But you don't but in other jurisdictions like Guadalupe County and Medina County, they don't take your blood if you don't blow. Mm-hmm. So then you should refuse to blow, but you have no way of knowing that, mm-hmm. right? So I'm not sure. What do we tell? So if you're in San Antonio and you refuse to blow, they are going to get a warrant and they're going to take your blood.
And in some of these smaller counties, so it used to be the case, like in these smaller areas like Wilson County, Atascosa County, I used to be able to tell my clients 100%, don't blow. They can't get the blood draw warrant. You're good to go.
Right.
But that's not the case anymore. Okay. Now they have like no refusal weekends. And things like that, where they'll have a judge ready to go, especially around the holidays. So it's hard to have kind of a blanket policy.
Exactly right.
Because nowadays, a lot of these jurisdictions are going to get your blood.
Because you're allowed as a prosecutor to argue that if he was so sober, why didn't he just do the tests? Mm-hmm. We're allowed to make that argument. And so, and we've won cases where people look pretty darn good on the videos. Mm-hmm. Okay. But the problem is somebody who's been drinking isn't a good judge of how good they're going to look.
Right. They're not a good judge of their own
I'm fine. Let me do these tests, and they're not really.
It's kind of like when I'm drinking and I know I'm a good dancer, and then later on, people tell me how I did on the dance floor.
Yeah.
It's not as impressive as
the Elaine. You did the Elaine.
Exactly. So, and so this holiday season, we want you all to be safe. We want you all to be with your families, and we want you to make it to Christmas. Okay. So, don't drink and drive. If you've had anything to drink, call an Uber, get a relative to drive you home. But if you do find yourselves in trouble, something happens, you get a DWI, you get into a fight, with a relative over the Cowboys game, give us a call at BRCK Criminal Defense. We're happy to help. Our goal is to get your life back on track. and to get the least possible interference to your life, you can reach us at 210-874-5080. When you call, you're going to get one of our fantastic attorneys like Mr. Simpson or Mr. Heath or myself or Matt Allen or Jacob Lindberg. So take care of each other during the holidays. But if you need some help, don't hesitate to give us a call.
Have a good season.
Thanks for listening to So You Got Arrested. If you found this podcast helpful, share it with someone who needs to hear it. For more legal insights and real talk from the front lines of the Texas justice system, follow us and subscribe. And remember, BRCK Criminal Defense has your back. For more information, visit us at brckdefense.com.